I welcome everybody back, Alabama Care. Today we have Mrs. Jennifer McInerney with us from Carney Dye LLC, and we are going to be talking about supported decision-making, guardianship, and some of the alternatives. Mrs. McInerney, for anybody that hasn't met you yet, if you would introduce yourself.
Sure. I'm Jenny McInerney. I'm an attorney here at Carney Dye. I've been practicing law for 13 or 14 years. We do estate planning. We do a lot of protective proceedings, estate administrations. I do a lot of small business work, and my practice primarily focuses on the special needs component of all of those things I just spoke about. We've met before, Alex, and we've some of our sessions have even involved my daughter, who is on the spectrum and has other diagnoses as well. I have 2 children with diagnoses that make them classified as disabled, and I also have a 4-year-old who has speech delay. So I have 2 children with IEPs. So I have a little bit of a personal and practical perspective in this arena as well. You know, I always tell parents when I meet with them, I can assure every parent who's a parent of a child with special needs that I have the same fears, the same concerns, and have had the same experiences that they've had. So I kind of have that unique perspective in this area. So that's kind of why my practice has evolved to this area of the law.
You got some skin in the game.
I sure do.
And for anybody that hasn't seen it, I would definitely recommend going to the top of Facebook in the search bar and typing in Alabama Care and Jennifer McInerney. And you can see the last one we did, I believe it was 2 months ago. It was a great broadcast with you and your daughter, and a lot of good information in there, both from you and your daughter. I thought it was a very powerful broadcast that we were able to do.
Thank you.
And today, Mrs. McInerney has shared with us a slideshow that I'm going to pull my email, and I will present that. Let me open with slides so that you guys can have a link of that for after the broadcast. And let me share screen. And can everybody see this? Jennifer, can you see that?
I can, yes.
Okay, perfect. If you would like to kick us off here, we're going to be talking about supported decision-making.
Right, so I forgot to change the date there on the first slide, but this is a kind of an expansion of the presentation Jack did back in November. So we're going to cover some of the same topics, maybe a little differently, maybe with a little different perspective, or a little more concentration on the perspective of parents with special needs children. And so today we're going to talk about that supported decision-making that can involve protective proceedings, which are legal proceedings. It can involve estate planning. So looking at whether or not your children have enough, your adult disabled child has the requisite capacity to execute an estate planning document, or the requisite capacity to execute a less restrictive option than guardianship for like a power of attorney or healthcare directive. And then just general supported decision-making, you know, how do I choose the best option? We're going to talk a lot about your team. We use that phrase and that terminology in our house a lot to talk about our team for our children. So I usually reference my daughter's team. My daughter's a senior at Mountain Brook High School. As I said, she has been diagnosed with autism and other diagnoses as well. And she has a team, and that team, we have told her, will go away when she graduates, but it will be replaced by a new team of specialists and care providers. And, you know, all of those people who are part of your child's team have a unique perspective about their abilities and their capabilities. And they all play a role in helping us make the best decision for our child. And even though in one form, it goes away when they graduate high school. It kind of picks up in a different way with like vocational rehab and the service providers through them rather than through your school. So that when I talk about your team, I'm referencing, you know, kind of all of those people involved in your child's medical, their, you know, therapies, their service providers, their social workers, any of those individuals could be kind of grouped into that team perspective.
I'd like to ask, we talked a little bit before going live, and I mentioned that I felt like guardianship was kind of not a good feeling for the community right now, but supported decision-making is kind of getting a lot of effort behind it. And what are your thoughts on that?
You know, it's a great question. And I kind of personally, I understand why some parents would want to go straight to a guardianship. But I also think that once parents can learn about other options and they can learn that we don't have to take this drastic step, we can do these other things first. I think I always encourage the parents to kind of, when they come in for a consult, let's say for a guardianship, I always start by asking them, you know, kind of what, other than a diagnosis, what's prompted you from wanting to have a guardianship? Because a diagnosis does not equal guardianship. Just because your child is on the spectrum doesn't mean they need to have a guardianship. You know, your child may have the necessary capacity to execute documents that would still give you the ability to talk to doctors, the ability to handle their finances, and to kind of do all of the things that you would do as guardian without taking those drastic steps and those rights away from the children.
Yeah.
So I'm kind of in line, you know, I understand why parents would want a guardianship. But personally, I personally, even with my own children, take the less restrictive option, knowing that down the road, if we need guardianship, we can still do it. But as we're starting as 19, I want to give her the opportunity to kind of make some of those decisions, you know, even if she fails, you know, giving her that opportunity to be an adult.
Now, if you mentioned that later down the line, there could be an opportunity if there needed to be for guardianship. If someone is granted guardianship, can that also be taken away or given back?
It can. You know, you can have a guardianship. It could be a temporary situation where someone needs guardianship. You know, maybe it's a short-term period. There's a diagnosis. Maybe there's a treatment period where that person can go through the process of getting their rights back and terminating that guardianship. I believe Jack mentioned in y'all's presentation, you know, ADAP has done a lot of work in reversing some of those guardianships or undoing those guardianships and giving those individuals their rights back. But the same thing, you know, I know by not proceeding with guardianship with my daughter when she turns 19, she's 18 now. Mm-hmm. By not taking that step, I know that down the road, if she gets in trouble or if she gets taken advantage of, or any of those concerns that I have that quite frankly are kind of likely to happen, we can always get guardianship. Mm-hmm. You know, it's not like if we don't do it at age 19, we'll never be able to do it. That's just not the fact. So, you know, I always recommend for anyone who's considering guardianship or anyone who has a child with a disability, even if you don't have a child with a disability, as soon as your child turns 19, you know, you're no longer their guardian. They're a legal adult. So you no longer have rights to their medical records, their school records, their financial records. And so, you know, my daughter who's 20, when she turned 19, she executed the same documents that we're going to talk about today, not because she has a disability, but because she wanted to make sure if something happens to her, we could step in her shoes and handle her affairs for her.
Mm-hmm. I think a lot of parents are feeling that now, kind of the least restrictive way.
Mm-hmm. Starting there, and I think it's a great perspective to have.
Mm-hmm. Kim Spangler says in college, in any form, or if college in any form is an opportunity for a person after high school, most colleges and CTPs require a student remains their own custody and is not relinquished to anybody else. So if you're thinking about going to college, keep that in mind. Is that, are you familiar with that?
You know, I've not personally dealt with that. So my daughter will be going to school next year. I mean, but you know, what guardianship is essentially saying is that person lacks capacity. So it makes sense, right? That if you have a legal proceeding where it's been determined by a judge that you don't have capacity, right? So you're not going to be able to transact on your own accord if someone has guardianship of you. And that's one of the benefits of having those less restrictive options of having a durable power of attorney or healthcare directive. While I have that for my daughter, she can still make those decisions, but I can also make them if she runs into trouble. And so it's not taking it away, it's just supplementing what she has.
I feel like we're kind of jumping around a lot of the slides that you have prepared. So I want to go back and share the PowerPoint and give a shout out back to Carney Dye, because you guys are on with us every month and answering questions about legal advice that a lot of us don't have. And for everyone watching, I want to say that I did sleep last night. My eyes look really dark right now because I shut the blinds. My computer dropped down, but I promise that I did get enough sleep last night. Okay. If you would just give us a little bit of background on Carney Dye.
Yeah, so Carney Dye, as I said earlier, we practice in estate planning. Primarily, I focus in special needs planning, estate administration, trust administration, guardianships, conservatorships, and business succession planning. We have 3 attorneys, Jack, Shannon, and myself.
And for anybody looking at getting an attorney here in the Birmingham area, I highly recommend going to Carney Dye. They're central to the area, and they're always willing and able to help. So let's talk a little bit about here you have some speaking for someone else situations, which I think are great. I always resonate with examples. So if you could kind of walk us through a few different examples.
Right. So I mentioned here protective proceeding. You know, what we're talking about is, you know, speaking for someone else. So situation, my oldest daughter, who I just referenced, is 20 years old. She is a legal adult. In the state of Alabama, you're a legal adult or you reach the age of majority at age 19. Most other states, that's 18, but in Alabama, it's 19. So she's currently a student at NC State in Raleigh, North Carolina. And if we want to make an assumption that, let's just say she's struggling with being away from home, the anniversary of her biological mother's death is coming up and she's having trouble with one of her professors. Then assume that I reach out to the department chair and express my concerns for her well-being, but I'm told that they cannot speak to me because she's an adult. So that's a perfect example of how having a power of attorney, healthcare directive, you know, having those documents in place would allow me to make a phone call if I needed to contact her therapist and say, hey, you know, she may not be sharing this with you, but we have concerns about X, Y, and Z. As an adult, I can't do that right now without those documents. I can't, you know, log into her bank account to see if she's spending money she shouldn't be spending. You know, I can't do any of those things. But with these documents, I can. It gives me that authority to kind of step in. You know, before the age of 19, I could do all of those things as her parent. But once she turns 19, those rights that you have as a parent to speak for your child goes away.
So it's something you have to plan for before the age of 19. And in being in North Carolina, there's quite a big geographical distance there. So making sure that everything's set in place before, you know, your son or daughter moves states away, and you're like, oh, wow, I called and I can't get this information, or I can't, you know, check on her in that way. And then you got to drive up there and go from there.
And, you know, it's typically in the summer, you'll see on different groups on Facebook, you know, a lot of chatter with parents saying, oh my goodness, I saw somebody mention something in another post that we need to have these documents in place. And theoretically that's true. It'd be great to have them. You don't have to have them, but it is good to have them. And to remember that in other states, the age is 18. In Alabama, it's 19. So your child, if they're going to Georgia, won't necessarily be able to execute those documents when they're freshmen because they're not 19 yet.
Oh, yeah. A little loophole there. So let's go through some other examples.
Right. So again, that's age of majority is 19, and you can no longer act as a legal authority and speak on behalf of your child at that point.
Same rule regardless of the child's level of disability.
Right. It's simply an age. So you may say, well, mentally my child is at 5, so I should be able to speak for them. Mm-hmm. Under the law, you can't. Now, some doctors will continue to speak to some parents, but technically they shouldn't be. Mm-hmm. And that's something to always kind of keep in mind, assuming, say, oh, your doctor continues to allow you to make those decisions and speak to them about your adult disabled child's well-being. And that's wonderful. And sometimes that does happen, but what happens when that doctor retires, or if they're not there one day and you have to see a different doctor and that new doctor says, they're 20 or they're 19, I can't talk to you. What's important about, kind of that age of 19 is if your child has a condition that will worsen over time, it would also be important to have them, if they have capacity at 19, sign those documents, because if you wait till they're 30, by then they may not have the capacity to sign a power of attorney and advanced healthcare directive, and you will have to go through a guardianship proceeding to be able to have that authority to speak on their behalf.
So there are a few different options at that point.
Right. So as I said, if they have capacity to sign a document, a legal document, then there are options. You have the power of attorney, you have different authorization forms, you have advanced healthcare directives that you can sign for the medical perspective. But there's also limited guardianships and guardianships when we think about being able to speak for someone else who is an adult.
And we're going to go through each one of these. Let's see here. So what exactly is guardianship?
So a guardianship is a legal proceeding where an individual's rights are essentially taken away by a court and given to another individual who's called the guardian. So a similar proceeding is the conservatorship, which is listed below, which is the same type of perspective, but it's over someone's financial affairs. So a guardianship is literally over that person. As a guardian, you make the decisions of what doctors they go to. You make the decisions of, where they live and what they eat and what they do. Kind of like you do when they're a minor, you make all of those decisions for them. As a guardian, you're going to make those decisions over the person. So where they're going to live, who they see, all of that is determined through a guardianship proceeding. And the conservatorship is the same concept where the court determines that the person can't handle their financial affairs and they appoint a conservator to handle those financial affairs.
I'm sorry.
No, sorry, go ahead.
Guardianship is kind of the most restrictive in those examples that authorization forms, power of attorney, limited guardianship, and then guardianship is kind of the most restrictive where the individual is giving up a lot of their decision making there. I do like the idea of conservatorship for someone that maybe has a little trouble with money. But
yeah, so what I would tell you is I would avoid a conservatorship if you can by having a special needs trust. And the reason I say that is because a conservatorship can be costly and expensive. If let's say you have, just for ease of example, 100,000, let's say the individual who needs to be protected has $100,000. So our options could be, we could put it in a trust or we could put it in a conservatorship. And in order to control and manage it, let's say they're being easily influenced by other people, they're being scammed on a regular basis. This happens a lot for individuals who have disabilities, or as parents age, sometimes we see this start happening as well. So you can put that money in a conservatorship, and essentially you have to account as a conservator. If I get appointed as a conservator for my daughter, I would have to account to the court for how I'm spending the money, down to the penny. You know, where I'm telling them how I'm doing it, what I'm spending it on. I have to get pre-approval for purchases, all of that. If I put the money instead into a trust, into a special needs trust, and I'm the trustee instead of conservator, I still have the same power. I'm still making those same decisions. She can't access the money. She can't access the money in conservatorship either. But I'm not spending money on court costs, and I'm not spending the money on an attorney to take me to court, to file all of these reports and do all of this. So this is why it's really important to come to an attorney who specializes in this area of the law to advise you. We have a lot of personal injury attorneys who will reach out to us and say, hey, you know, we're about to settle this case, and this individual is on needs-based assistance. They're on SSI. And we're thinking about putting in a conservatorship, and we'll say, don't do that, because if that will disqualify them from their SSI, they're going to lose their benefits. Let's put instead into a trust where that money can still be protected, but at the same time, it allows them to qualify for government benefits. And, you know, from a parental perspective, when I think about my daughter, who is very likely to be taken advantage of financially, just because of her disability. You know, we already have a special needs trust set up for her. So anytime that we want to gift her something, we gift it to the trust, because then we're still managing it and we're still in control of it. She can still ask for that money and say, hey, I really want to buy X, Y, or Z. And we, as the trustee, can make that decision if she can have the money for that. That also reduces
somebody wanting to get a conservatorship.
Pardon?
What would be a good example of somebody saying, no, we don't want to get the trust, we do want to actually have a conservatorship?
You know, different scenarios. You know, sometimes we have an emergency situation where an older individual is being taken advantage of financially, and we need an immediate solution to kind of protect assets while we at the same time are trying to figure out what assets there are. That would be a really great example of a conservatorship, especially if there's multiple people involved and you really need that court intervention to help facilitate any potential disputes down the road. But, you know, conservatorships are used for minor children all the time, or for adult disabled children as they become adults. And that's just because, you know, maybe the attorney handling a case or a matter just aren't as familiar with special needs trusts.
So really, you would say to anybody coming in thinking about conservatorship, kind of toss that out the window, we'll go through it, but really you should be looking at a trust.
Yeah, again, it's looking at the less restrictive option. So that's where we always start in any conversation with a parent, is, or an individual coming in saying they need protective proceedings over any individual, whether it's a child or a parent or a friend, a loved one, is we start by saying, you know, let's talk through why you're here, what's happened. And then we talk through, okay, so we understand the situation that's prompted you to come, but medically, are they capable of making these decisions on their own? Are they capable of executing a legal document like a trust, or like a power of attorney or other documents? And kind of walking through, like, let's step back and let's just walk through this step by step to figure out what is the best situation. Truly, you know, some parents come to us and they say, okay, so let's do the power of attorney and healthcare directive. It's a lot cheaper than a guardianship proceeding, first off. But they say, I don't know if my child has capacity to sign a document. And the average the average individual on the street doesn't understand, they don't know, and they're not trained in knowing what capacity is required to sign a legal document. And that's what we're here for. You know, we're trained in knowing if a person has capacity, what questions we can ask, how we can assess that individual just before they sign a document. And, you know, sometimes, you know, just this morning, I did a Zoom call with a client to assess their disabled child's ability to sign a legal document. And I sat down with the child and had conversation, asked questions. And, you know, just because your child has a diagnosis or a disability does not mean they lack capacity to sign a document. And that's really important for a lot of parents to understand. You know, my daughter has autism. I know that she understands what a power of attorney is because we've talked about it over the years. She doesn't know or understand every detail of the document. If she were to read it, she couldn't summarize the entire document for you. She understands that by signing it, what it will mean. And that's important as a parent to understand. She would have enough capacity to go out and give her money away, right? If someone came along, she would have capacity to sign a legal document. But most people who sign a will, even without disabilities, couldn't tell you every single detail or what it is. And sometimes we get caught as parents with disabled children saying, oh, but they won't understand it, so they won't be able to. But that's not necessarily true.
I think I don't understand a lot of the legal jargon. That's why I call you guys like, hey, what does this mean?
Right. And oftentimes parents with disabled children think, oh, there's no way they'll understand that. So they don't have the capacity. But neither do their peers who are their same age who are neurotypical. They don't know the details either. So you have to come, it's better to go to a professional who specializes in this area to help you make that decision as a parent.
Yeah, when you're talking a lot about going through with the family and planning these things, it makes me think of like a family therapist or counselor that, you know, is kind of the underlying base there. And then you bring the expertise of all the legal, but, you know, really helping and caring about the family is the underlying thing there. If you don't mind me asking, what are some examples of questions that you went through like this morning to find out if somebody has the capacity to sign?
You know, so it depends on the individual. Well, I usually just have a general conversation. I introduce myself. I tell the individual, you know, why they're talking to me. I explain who I am and what my role is. I tell them or have a conversation about, you know, what prompted their parents or their loved one to reach out to me. And I ask them if they have any questions or concerns about what their concerns are. I ask them what they want. I ask them if I prepare a specific document, if it's something they would feel comfortable signing. Some individuals I go through, depending on the individual's diagnosis, I have a mental health provision I put in all of the advanced healthcare directives that for individuals who have mental health diagnoses, where the individual can very specifically identify specific treatments they would or would not want if they were involuntarily committed somewhere, specific medications they would or would not want, specific hospitals they would want to go to, doctors they would want consulted, medications they would or would not want. And, you know, for like my daughter with autism, she doesn't like to be touched. So I make it it's clearly stated. And for some individuals, you know, they can put things like, if I'm in a heightened state, I don't want to be touched. I don't want these things. And so those are some of the conversations that we have is, you know, if you're in this situation, what would you want someone to know? And, you know, depending on the individual, we can get very specific, and some individuals, not so much. It just kind of depends. But generally speaking, it'd be like any conversation that I'd have with you sitting here. Just even if you were coming to me to execute some documents, I would ask you, what are your wishes?
Yeah.
And if you did this, would you feel comfortable doing it?
So just taking them through the process, trying to figure out what they want. Now, when you spoke about guardianship, there was another option there. I don't want to say another option, but guardianship short form. What exactly is short form guardianship?
So the guardianship short form is a little bit more of a condensed version of a full guardianship. It's the same concept of this. You have to go through the same legal proceeding. The form itself is condensed because it's only for situations where a parent or guardian or custodial of the individual can file. So mom and dad, I need guardianship for my adult disabled child, that type of scenario. In that situation, you still have to have certain requirements met, like having a note from a doctor who's certifying or testifying, providing that documentation that the individual has a diagnosis, which makes them unable to care for themselves. And you still have to have the consent of the next of kin. But the process and the proceeding is a shortened version. It's not as lengthy. And the assumption there is, as a parent, the previous 18, 19 years, you've been caring for that individual and making these decisions for them. In most situations, it is in the best interest of that disabled child to have that guardianship relationship continue with their parents.
Now, when you say it's a little bit shortened timeline, I'm going to reshare the screen there, but about how long does it take or how do you apply for guardianship?
So as it kind of sets out here, having that doctor's note, the petition, the consent of a relative or next of kin. And you do have to file that petition with your court. You're filing it in the court where the individual is located. And the consent of an adult relative. A lot of situations where we're doing the short form, we're having a sibling sign that consent as the next of kin. Is notifying your relatives that, hey, mom and dad are doing this. Do you have any objections? Do you consent? Are you okay with this? Do you have any concerns? But the idea is that the shorter version, depending on the court and how backed up they are, it could take a month or two. It could take a little bit longer, just depending on what the court calendar kind of looks like. But these proceedings are pretty straightforward. And the court still appoints a guardian ad litem to kind of meet with the family, meet with the child, just to make sure that a protective proceeding is necessary. As we're talking, it's subjective if someone needs a guardianship. If mom and dad thinks it and the attorney agrees or the attorney's on board for it, but let's say a guardian ad litem is appointed and they think, no, this is just not necessary. They can report that back to the court. And the whole point with a guardian ad litem is the court appointing somebody who's not the attorney, who's not the parents, but still has that same knowledge base to be able to assess whether the individual needs protection, to go talk to that individual and talk to the parents and make sure there's nothing fishy going on, make sure this is really, truly necessary. And then that guardian ad litem reports back to the court if they think that this is proper.
It's good to have a third party.
Right.
Doesn't have any skin in the game, but is able to make a non-biased decision on behalf of all entities there.
Right. And, some parents may say, hey, my child's nonverbal or they're wheelchair bound, or, the guardian ad litem can come to you. You don't have to put them in a vehicle and schedule an appointment and have this big production. It's really, truly not like that. Guardian ad litems are very flexible. A lot of them will come out to your home, to a hospital if your child's in a hospital, and have those conversations with you. And now with Zoom being so readily available for everybody and everyone's kind of using it now, is making it easier for parents with disabled children to have those conversations with guardian ad litems and attorneys, where before it was very difficult for parents maybe to leave their disabled child to go have these meetings.
How do you become a guardian ad litem?
So a lot of guardian ad litems that are appointed by the court are attorneys who practice in this area of the law. And then other ways are, most of them are licensed attorneys who go through a training.
So it's not like just because you've been in the disability community, you can apply to become a guardian ad litem.
Right. It's because you have to have that legal kind of perspective. I know I'm also licensed in the state of Mississippi, and they offer a free 3-day guardian ad litem training program. And I actually went through that program just to kind of see how it, you know, differed and what's taught. You can kind of research and see what it is, but it's truly looking at the individual, making sure that situation in the perspective of a guardianship proceeding is proper. Like we've said, it is the most drastic step that you can take. And so you want to make sure as a guardian ad litem that it's truly necessary for that individual before you kind of sign off on it.
Have you ever like that third party where you've come in for the family or for the individual?
Not in a guardianship where I've had to contest it, no.
Okay, let's jump back to the PowerPoint here. And we're continued. I think you kind of went through some of this, but if you would go ahead and just...
So right, so guardian ad litem is appointed by the court. And I always like to tell my families when they're going to meet with a guardian ad litem, I always tell them, you know, this is the way for the court to have a one-on-one experience with you before the hearing. And the court can't go out to everyone's home and meet with every family. So they appoint somebody in their place to do it for them. That's how I always like to describe it to families. And the guardian ad litem will typically meet with the family before the hearing. And like I think Jack said, the last session, you know, these hearings can, you know, they're very informal. They can last just a few minutes. Generally, the judge will talk to the parents and answer any questions they have, talk to the individual who's the protected person, see if they have any questions or concerns they want to voice. But, you know, also Jack said, obviously this depends too if the guardianship is contested or not. Obviously that's a longer process.
So now that we've covered guardianship, let's move on to conservatorship, which focuses more on the finances there.
Right, so we talked a little bit about this earlier. We talked about, you know, assume your disabled child receives $100,000, but they can't manage it, so it needs to be put into conservatorship, or they're being taken advantage of and you need a quick solution to kind of protect their assets in a really quick way. What it does is it reports to the court what all the assets are that need to be protected, and then the conservator who's appointed has to post a bond, which is kind of like an insurance policy for the amount of the assets. What you don't want is your conservator going out and spending the money and then saying, oh, well, you know, behaving inappropriately. That bond protects the court from any wrongdoings of the conservator. And so you have the bond, and then you have the reporting that you have to do for any expenses or anytime that you use funds from the conservatorship. Let's say that the conservatorship is protecting you know, houses. Let's say your protected person has 4 houses that need to be protected, and you need to sell one of the houses to help pay for medical care of the individual. You have to go to the court and you have to ask for permission to sell the property. Then once you get a contract on the property, you have to petition the court and say, hey, this is what the contract price is. This is what the appraisal price is. Will you approve for us to sell the house at this price? So it's a little back and forth. Like I said before, it's a more expensive way to handle funds. In some situations, it's necessary to have a conservatorship, but for parents with disabled children, I'd always recommend doing a special needs trust, because it's not as much oversight and it's not as expensive. And when I say by expensive, I'm talking about attorney's fees.
It seems like a lot of people with the courts.
Right, and probate court is very informal, and some courts are very quick, but some courts can take a while, and that can be very strenuous on a contract when you're trying to sell a piece of property, but you're waiting for a hearing to then get it approved. It can just take extra time.
Now, with conservative finances there, you also have representative payee program.
Yeah, so that's with Social Security, where it's essentially saying that someone else needs to receive their Social Security or needs-based government payments because the individual or the child can't manage those funds. So, so for example, with my daughter, she's 18. Let's assume, for hypothetical purposes, that I'm going to file for Social Security for her for disability. If I did that, I wouldn't find it necessary to be her rep payee, but I would have those funds, let's say, go to her ABLE account. Mm-hmm. And knowing her ABLE account has to be spent on qualified expenses, that's one kind of way you can have that oversight that the funds are being used appropriately.
Yeah, I still get that.
I always talk about, I love ABLE accounts. I think everybody should have one. If you have a child with a disability, you should have an ABLE account. There's so many great ways to use those accounts. They're flexible. They are just, they're really, really wonderful tool for the community. And
the tax advantage that you guys get from that.
Yeah, it's amazing.
Yeah, it's really well worth it there. Now we've gone over the guardianship, the conservatorship. I'd like to move on to, I think what is the hot topic for a lot of the community here is the supported decision-making. And that's a word, that phrase has been thrown around a lot. I've had a lot of mothers and parents say, hey, can you tell us more about supported decision-making? This is what my son or daughter is going through. This is what we're doing for them. So if you could give an overview to anyone that's unfamiliar with it.
Right, so supported decision-making, is any of these processes that we're talking about. We're looking at a situation where the individual maybe struggles, maybe he's not on the same kind of playing field as their peers would be at the same age. So my daughter has a really hard time managing money, understanding the concept of money, understanding the concept of saving money, understanding the value of money. All of those things I experienced as a parent. So I understand why parents struggle with this decision and knowing what to do for these situations. It's kind of what we talked about before, sitting down with the parents or the team and saying, okay, so what is the situation? Let's assume we do not need a guardianship. Let's assume we don't need a conservatorship. What are our issues? And as a team, identify very clearly what those issues are. There may be a legal remedy outside of guardianship and conservatorship. When we think about powers of attorney, we may think, oh, well, that's just something, my parents have. That's really not something my adult disabled children need to have. What's really critical about, let's say, our durable power of attorney is it's very robust. It has a lot of powers in there that you're not going to find by just pulling it off the internet and printing it out. It has robust language in it because we deal with individuals with disabilities and we deal with individuals who may need protection in the future. And so we build those documents with that in mind, with knowing, hey, you know what? We may down the road need to appoint a conservator. This document already names who that person will be. You know what? Down the road, we may need to set up a trust for this individual. Our documents give your power of attorney the power to establish a trust. All of these things, where we can say to parents, you might not need these things now, and you might just be worried about them in the future. Let's get a document in place that would give you the ability to do those things down the road. Mm-hmm. You don't need to jump to guardianship just because you have these fears for down the road. And then, you know, kind of thinking big term of, you know, what are our concerns for today? I always tell families when they're coming in for special needs planning, think about planning for right now. Don't think about 20 years down the road. Think about something, you know, terrible, a family disaster happening today. If that happened today, what do you have in place for your disabled child? What structures, what team do you have in place? You know, move through this process in estate planning as if something bad is going to happen in a week or 2 weeks. You know, 10 years from now, we can revise these documents. If the situation has changed, we can always amend or always redo certain things, but always have a plan in place for your disabled child. You know, we talk a lot about estate planning at the beginning. We mentioned one of the most critical pieces for a family that has a disabled child is to have a good estate plan in place. And that is because you want to make sure it's not just about whether or not your child will inherit money, but how they'll inherit that money. We were talking a minute ago about conservatorships. That's a perfect example. If a parent has just minor children and both parents, let's say, are in a car accident and die, a minor child cannot just inherit that money. The money would have to be protected. In that situation, a conservatorship would be put into place for those children, where the court would be holding the money on behalf of those children until they turn a certain age, until they turn 19. Mm-hmm. And so, you know, for a lot of times when I'm talking to parents who have disabled children, you know, I try to stress to them you know, for me and my husband, you know, we set up a special needs trust, not just so that we could protect assets so my daughter could qualify for benefits down the road if she needed them, so that we knew somebody would always be around who we trusted to manage her finances, so that she won't get into a situation where she has a lot of money and may get taken advantage of. We already have a safety barrier in place with that special needs trust because we have trustees appointed after us. That if something happens to us, there's a fallback provision of who will manage her money. And that's the beauty of doing planning before you're in a crisis situation.
I'm sure that takes a lot of worry off of your shoulders and your family's shoulders. I think a lot of families, you know, are starting to get to the point where they're thinking about doing an estate, or their son or daughter's getting older and they're not sure what they want to do. And it's like, yeah, we'll do it eventually. Well, you know, it's a few years later at that point, they're still thinking about it and still worried about it. So I'd recommend, you know, definitely, it can seem like a lot. It can seem like a lot to start the process, mm-hmm. but there are tools out there to help you. And we'll kind of, Mrs. McInerney will kind of go through some of those tools, but start the process earlier rather than later. And it's not as overwhelming as you think once you dive in. A lot of times I feel like we view challenges throughout our life where it feels like climbing Mount Kilimanjaro. As long as you start, you just look at the next step in front of you, and then, you know, a day later you look down and you're already at the summit. So that's right.
And, you know, I always tell parents, you don't have to have all the answers when you come in to meet with us. The point is for us to, you know, a lot of the times we can help guide you through that process and figuring out who these individuals can be to play these certain roles in the event that something happens to you and your spouse. You know, because this is what we do every day, we may have ideas that you haven't thought about of individuals. And part of that process is us helping walk you through it. So you're not doing it alone. We don't say, hey, tell me who these people are and we're done. We help you through that process. We help you brainstorm and think about those people.
So we mentioned that there are some tools there. I'm going to go ahead and share the screen back to the slideshow here. And if you could introduce the ABA's practical tool.
Yeah, so Jack shared this last time. You can Google this, and it's a PDF. You can pull it and print it and keep it as a resource. As we were talking today, kind of our perspective and our approach to protective proceedings or helping parents or individuals who have concerns about an individual needing protection is to start off with that P, that presume. You presume that a guardianship or conservatorship is just not needed. So if we start there, then we can start thinking about other alternatives. And for some parents, they may not know other alternatives exist, and that's what we're here for. Mm-hmm. The next is to reason, and that's what I said earlier. You know, what has triggered you to make the phone call to come in today? Has an event occurred? Has there been, has your loved one been taken advantage of? Have their finances been taken over by someone else? Have they been conned? Have they been scammed in some way? You know, ask, you know, is it a temporary, or is this a reversible situation? You were talking earlier, you know, there may be a situation where a guardianship is needed for a short time period. I had a client who consulted me for their brother who was in the hospital, really bad situation. He wasn't able to manage his affairs or do anything. There was no power of attorney. There was nobody there to make sure his bills were being paid, and his mortgage was being paid, that anybody was handling anything. There was no documents in place. And in that situation, we had to get a guardianship and conservatorship set up so that we could start gathering information that we needed to do a Medicaid application for that individual. So, you know, in those situations, you know, you're looking, is this short term or is it long term? And that can also help guide what direction we're going to go in.
As you guys can see some of these tools here, and there's quite a bit. I'm going to go back because we're not done yet.
Right, so the community and the team and identifying the person's strengths and weaknesses. You know, sometimes, like I said earlier, that those other members of our team, they can have perspectives that sometimes as parents we may miss. You know, they also may see our children or adult disabled children in environments that we don't see them in, and so they may have a different perspective. And, you know, having that team help us make those decisions is really important. It's also important to identify who that team is. It doesn't have to just be your speech therapist. It could be mom's best friend who comes over for dinner once a week and knows how mom and dad have parented the child, and they know kind of what the challenges are for that child. The child's comfortable with that individual, that child trusts that individual. You know, that identifying who that team is. You know, if something were to happen to me and my husband, I wouldn't want my oldest daughter being in charge of my youngest daughter's finances because it could cause conflict down the road. If big sister won't give little sister the money she wants from her trust. So, you know, you have to think outside the box, you know, outside of your family. I always tell clients, you know, your family is not your box or your parameters of who you can include in your estate plan or in any of these decision-making processes. Think outside the box. Think about friends. Think about people who have played a role in your child's life, who know your child, who knows their strengths and weaknesses. They're part of the team. Identifying who those people are and including them in the process, including them in the documents and in the process, so that they're a piece of it down the road is really important.
I think it's really good to have a robust team there. And even for like any challenges that we have in life, being able to rely on that team, different expertise there. And I almost think of it like a board for a company, you know, a support system there. But do you ever feel like a family is hesitant to reach out and ask somebody to be a part of that team, or that somebody might be hesitant to commit because they're unsure of what that entails or time commitment and stuff like that?
Right. That's a great question. We actually get that question a lot. I actually have parents who get concerned because they say, oh, I want to name so-and-so to be guardian, but, you know, I haven't had that conversation with them yet. And I want to make sure they're okay with it. And what I tell them is if you want to name that individual in your estate plan, or you want to name them in a specific role, You don't have to have their written permission to do so. You don't know when a situation will arise where your adult disabled child or even minor child will need those documents in place. And so hypothetically speaking, let's say I name my best friend, Kristen, to be the guardian of my little boy, 4-year-old little boy. I didn't go ask her, hey, will you be guardian if something tragic happens to us? You know, she would think about, well, could I really take on a 4-year-old? But if something happens to me, my husband, and we're tragically injured, she would be first in line. And she could say, at that point, yes or no. Hey, Jenny wanted me to play this role. She wanted me to raise her son. Wow, you know, what a privilege. And allow them that opportunity at that time to speak up. If they don't want to fill that role, they can simply decline and it can pass to the next in line. And that's why it's always important to have multiple layers built in. I always tell families, you know, when you're building in those trustees of your trust, your special needs trust, it's important to kind of have a line in place if possible. If something happens to mom and dad and you've named grandma, well, there's a chance grandma predeceased mom and dad. And if that's all you have, well, then you're going to need to go through a process. You just have to spend legal fees to get someone else appointed. So having multiple people in place is important. And, you know, just always kind of keep in mind that you don't necessarily have to get their permission to list them. Now, obviously it would be nice if they agreed and kind of took on that role, understanding what was going to happen. But it's not legally required that in, say, a power of attorney, you've gotten permission from everyone you're naming as an agent to be an agent.
Yeah, but I like how you said it gives them the opportunity to step in that role if they choose to do so. I'm going to go ahead and reshare here, and we will finish up the practical tool.
Yeah, when you're thinking about the supportive decision making, thinking about those challenges and thinking about not just the immediate reason why we're here today to talk about a protective proceeding, but what challenges in the future might we have that we can anticipate and plan for. The appointment of a legal supporter to help make decisions, that would be your healthcare directive and your powers of attorney. And then if the guardianship is necessary, think about if there's a way to limit it. You know, is there just one area that we're needing guardianship for? Can we restrict it in some way so it's not a total takeaway of that person's rights? You know, we're always looking for ways for that individual to maintain autonomy and control in some way. You know, a lot of us, you know, we like to make our own decisions. You know, our children are no different. Our loved ones are no different.
Yeah, I don't like people making decisions for me.
But, and then, you know, always keeping in mind, you know, when you consult with an attorney and you have these conversations and you think about the future and the future challenges, you know, we can set up a durable power of attorney and a healthcare directive for my daughter, say when she turns 19. But at age 24, she may decide that she wants to tear them up and revoke them. She can do that. If she gets in trouble, our options at that point would be guardianship or conservatorship, and we would have to justify it to a court why we felt it was necessary to do something like that. But she has a right to revoke those documents. She has a right to name somebody else if she wants to. If she's being taken advantage of or she's in harm, then we would have grounds for stepping in and trying to get the court involved in some way. But always knowing as a parent, if you have an adult disabled child, if you begin with that less restrictive measure, you can always go up that path. It's, you know, it's not as easy to go back down. So starting at the bottom and going up when necessary is always the best course.
Yeah, I think starting at the bottom and going up. I like how you said that they can always revoke some of those powers. It reminds me of like if an individual is receiving services, get along with their case manager, who is kind of their point of contact with the state, or there's some things that they don't think their case manager is doing well. They can always ask for a different case manager or a different provider. So the decision's always theirs. And I think it should be.
Yeah, I agree. And, the same thing, if my daughter at some point says, you know what, I don't want you having access to my bank accounts. You don't need to have that. She has a right to tear that up. And as a parent, I have to accept that.
I remember when I first moved to Alabama, I was looking for a new bank. I had Wells Fargo out in Phoenix, Arizona. And my family here was like, oh, go to Service First. They're a great bank, a smaller bank. And I was like, okay, I'll try them out. And I made certain when I was at Service First opening my account, I was like, I don't want anybody else in my family to be able to log in and see my checking account. You're spending too much on takeout, too much on food. Like, nope, that's my business. You guys don't have any access to that. So um,
And that's a great point, because we actually have a lot of clients who come to us not dealing with adult disabled children, but maybe with their parents, where they're concerned about how they're spending their finances. And they'll say, should I get mom and dad to put me on their account? And we walk through the benefits, the pros and the cons. You're like, well, here are the bad points of doing that, and here are the good points of doing it. So we always tell clients, if you have a parent that's aging, that you have concerns about their capacity, you need to come talk to us as soon as possible so that we can help you plan for their maybe potential incapacity. If they've been diagnosed with dementia, if they're mishandling their funds, come see us, because there may be steps that you can take now that will help you in 5 years that you just might not know is an option right now. But by planning and being proactive, you can really protect your parents in a better way. So, when you think about all of these proceedings, I kind of focused it a little bit more on a parent with a special needs child that's coming of the age of majority. But truly, this applies at any point in someone's life if they're needing protection. I mean, it can happen when you're 40, it can happen when you're 80, it could happen at any stage of life.
And I am on my grandmother's checking account in case something were to happen to her. I can continue to pay those bills until she gets better.
Right.
Now, we talked about guardianship, but there's also limited guardianship.
Right. So this is, and I know Jack covered this in his November presentation, if anyone wants to, compare and contrast these presentations to see what information he covered maybe a little differently. But, like I said earlier, if you do feel like you have to do a guardianship, there may be options to limit that guardianship in scope so that you're not fully taking away the individual's capacity and ability to do things. So you may, let's say, have a guardianship appointment for just healthcare. Say that individual's really struggling making healthcare decisions, taking their medications, following up their doctor's appointments, doing things that they need to do. You could have that guardianship that's just focused on that healthcare portion and not everything in the individual's life.
My phone's going off there. And I want to kind of jump around on this slideshow. ADAP has some great resources for guardianship. Mr. James Tucker and ADAP down in Tuscaloosa do a lot for the disability community. And so I can post these links there. But I want to, I think this is a great slide right here. Prior to considering a guardianship, determine if a disabled adult child has the capacity to sign estate planning documents, including. So these are some of the specific examples that I think are good for the community to hear about.
Right. So, a will, as we always say, so we typically, when we're meeting with a client, whether they're disabled or not, we always say there's 3 main documents in an estate plan. And the first is your will. Your will is your stuff, your things, your home, your car, the things inside your home and your car. That's how you'll dispose of those items through a will. And, just because you have an adult, just because you have an individual that has a disability doesn't mean that they shouldn't make those determinations of where their estate passes. That durable power of attorney, what we talked about earlier, helps manage those financial affairs. The HIPAA release and the Advanced Healthcare Directive give you the power to make those medical decisions. So even in that situation where maybe your adult disabled child just needs help with those medical decisions, making those medical choices, talking to their doctors, helping manage their medical records. I always tell parents, you are the expert of your child. If your child has a disability, I can assure you, as a parent with a child with a disability, I could write a book on what's worked and what hasn't worked over the years. I'm the expert. You know, my daughter doesn't remember if a specific medication didn't work for her. You know, she might have been younger and she doesn't have that memory, but I do. And I know what's worked and why it didn't work. And so that might be a way that as a parent, you could say, you know, I don't want to take all my child's rights away, but having that advanced healthcare directive or having that HIPAA release, that would be really critical to have in place should a crisis emerge. My child may need me to step up and help facilitate that. You know, when our children graduate high school, you know, disability or not, at the age of 18 and 19, they're going off to college. They're living on their own for the first time. They're learning how to grocery shop and manage a budget for the first time. And then we throw on top of it managing a new schedule in a new environment with new friends. And then, oh, and by the way, you also have to manage your health care. You know, you have to remember when to go make an appointment with your dentist. You have to remember when to see your psychiatrist, when to see your psychologist, when to get your prescriptions refilled. A lot of 19-year-olds, they don't have the capacity for such a drastic change and to manage everything efficiently. So whether you have a disability or not, having those documents in place can really help your child those first few years away from home, you know, when they're adjusting to a new life.
Mm-hmm. Yeah, that transition I got drugged through the mud during that transition.
It's really tough. And, you know, I don't think we prepare our children enough for it. You know, we do what we can. And then we say, well, you know, they're 18, they're 19, you know, it's time for them to grow up. But it's tough. And that's a really difficult transition.
Yeah, with everything going on there, I mean, I think I went to my dentist during the summer when I came back from school, and I went to the doctor, and the doctor was like, I went to the ER. You know, that's the only time
right.
So I had to go to the ER.
Right. And so for children with disabilities, it's critical that healthcare piece stay consistent and stay a priority. And for a lot of these children, their healthcare is not their main focus at 18 and 19. No, 20 through 24, like their health is not the priority. And we have to teach them that it is a priority, right? And they'll probably need help. Just because they're 19 doesn't mean they know how to do everything. They may think they do.
10 feet tall and bulletproof. And as I'm getting older, I'm realizing that's not the truth.
Right.
My knees are starting to go like, oh, geez. And an advanced healthcare directive and the HIPAA release.
Yes, those are your healthcare documents I'm talking about, which would allow your parent or the person you appoint. It doesn't have to be your parent.
Estate planning for those with a disability continued. And a lot of this we went over with Mr. Carney as well. But if we could just kind of re-summarize it.
Yeah, sure. So what I was talking about earlier, where, a parent may say, well, my child's on the spectrum, that must mean they can't sign a legal document. That's not necessarily true. Lawyers are trained, estate planning lawyers are trained in knowing how to assess an individual to see if they have capacity. But so are doctors, especially when you have questions of capacity. Maybe someone's been diagnosed with dementia and, it's been a few years, maybe it's not being managed properly. Before they sign any document, or, it's better for them to have a full evaluation by not just even a regular doctor, but maybe a neurologist to assess whether or not they have capacity to sign a document. That's really important for those older individuals.
Mm-hmm. Yeah, it's something that my grandmother, she takes a test every time she goes to the doctor for her 6-month checkup. It's kind of, I don't know what the name of it is, but it's remembering things or.
Right. And, the last point on that slide was, capacity could change based on the document that's being executed. So if you're talking about just a healthcare directive, that may be different than if someone comes in the door and they say, hey, I want to make a new will. I'm taking out all my children of my estate and I'm giving it to this guy met on the internet, and right. So that would require it. That would be a flag for us to say, let's have a doctor make sure before we take away everything for someone we've met on the internet. And we kind of laugh because it sounds stereotypical, but these things happen and people get taken advantage of, and you don't have to be 80 or 90 years old to get taken advantage of by someone on the internet. But
prints is a thing because it works.
Right. And so, I always tell people, it kind of depends on the situation. And if capacity is an issue, we do strongly request that the individual, before they sign any document, or even say we won't let them sign a document until they've had that approval from a neurologist stating that they have that capacity. And even in that situation, after that signing, as attorneys, we may go back to our office and write up a document that says, this was the situation, this is who I saw today, this was the condition they came in, these are the conversations we had, maybe to prove that capacity. Like I said, if a parent comes in and says, I'm taking my children out of my state plan, we'll need some backup to say they knew what they were doing when they did this.
Some documentation or recording or something. So there are other considerations when planning for estate planning for someone with a disability.
Yeah, so there are lots of different trusts, and different trusts can be used for different purposes. They serve different needs. A living trust is a really good way to set up and manage assets for a disabled individual who has significant resources. So in this kind of situation, you're not necessarily thinking of a 19-year-old. You'd be thinking more of an older, our parents who may need some kind of protection. This is what I was referencing earlier when I said, hey, if you've got concerns for your parents' capacity now, go ahead and come talk to us, because there are things we can put in place now that can protect their assets down the road. And a living trust, revocable trust, is one of those situations, or even irrevocable trust. If you have a trustee, that someone you trust, like if I was concerned about my parents, maybe I could be the trustee and manage their finances if I'm truly concerned that they're incapable, or they will be incapable of doing so in the near future.
I think you have to make sure you trust the person.
Yes, it's I always tell parents when they're doing a special needs trust for their children, the trustee is the most important role. It's not the beneficiaries, it's the trustee, because that person is the one who's going to determine how the money will be spent, and they'll determine how the money is invested and managed.
So spend time thinking about that and talking to that person. Okay, let's go back to as we're finishing up here, if there's anybody in chat who has additional questions for Mrs. McInerney and Carney Dye, go ahead and put it in the chat. But I'll let you take over here on looks like almost the last slide for us.
Yeah, so this last slide just kind of highlights that additional language that we can provide in that advanced healthcare directive for individuals who have mental health diagnoses. And the reason I put that verbiage in for our documents is, we have clients who have diagnoses which may trigger an involuntary commitment at some point. And in that situation, the individual wants to make sure that the treating physicians and the healthcare agent who's appointed for them knows what medications they want or what kind of treatment that they want. Being able to communicate. If my daughter is in a crisis situation, she cannot tell you, don't touch me. She can't tell you, if you touch me, it is going to make the situation 10 times worse. She doesn't have the ability to communicate. These are the medications that work. These are the medications that don't work. In a crisis situation, she wouldn't be able to do that. But what this document does is it allows her to make those decisions. It allows her to communicate all of that ahead of time and have it in a written form that can speak for her. And that's really important, I think, for individuals who have a mental health diagnosis, to make sure that those requests and that information is communicated in an event that they are involuntarily committed somewhere, or if they're just incapacitated in some way and they're receiving medical treatment, that the treating physician is aware of all of these factors.
Mm-hmm. Yeah, it's kind of, and we spoke about like the IEP and what was the letter of
intent.
Letter of intent. It's kind of like carrying that with you and having it as a backup plan, especially if something crazy happens and your world is kind of shook up. You kind of lose track and lose thought of some things, but to have that in your back pocket and be able to pull it out, whether it's a Google Doc or, it's something physical that you have on you, to be able to communicate your needs and your wants there, it's limitless. So, well, Mrs. McInerney, we don't have any additional questions. We have some links here from Kim Spangler on additional supported decision-making from out of state as well. So anybody that's interested in that, copy and paste that. And I'll go and we have some additional resources here from the slideshow. I'll go and copy and paste those into the chat as well. Mrs. McInerney, thank you for spending the morning and the afternoon with us.
Yeah, thank you. It was a pleasure to see you again, Alex.
Yeah, it's always a pleasure to have you on here. And I guess it'll be 2 months.
Yes.
See you again.
See you.
All right. Well, tell your family I said hi.
I will. Thank you so much.
All right. Bye.
Bye.